Hello, my name is Jacqueline Michelle Norris, and this is my case study presentation for EDL 853. Section 1, Case Summary. Here are the facts of the case. The setting is in Dover Unified School District and involves Nottingham High School. The school was built in the 1950s and is mostly renovated to meet federal and state accommodation for individuals with disabilities. Nottingham has a very popular football team, and the community supports not only the rest of the district with services for the schools, but parents, teachers, and community members devote Friday nights to watching the game where Miguel Hernandez is the star quarterback. During the game that cinched the semifinals, Miguel was tackled by the defensive lineman. To everyone's horror, Miguel did not get up. Miguel was permanently paralyzed from the waist down. He was resilient and soared through rehabilitation. He kept up with his studies. He and his parents contacted the school and planned to return with the counselor, Miss Guzman. The only accommodations that Hernandez family requested was wheelchair access to Miguel's regular classes. At first period, first of the day, Miss Guzman gave Miguel a new schedule and told him that his science class didn't have wheelchair access. Of course, that afternoon, Miguel's mother contacted the school and was very upset. A meeting was scheduled for that afternoon. During the meeting, Mr. Hernandez expressed anger that Miguel's schedule was changed and wanted to know why she and her husband were not informed. She let me know that Miguel needed to stay in his science class because it was a prerequisite course for the university that Miguel intended to attend. Miguel's mother demanded Miguel be re-enrolled in that science class. Before the meeting ended, a man named Howard Carey introduced himself as an attorney representing Miguel and inquired about the Rehabilitation Act of 1973, specifically Section 504, and stated that Miguel had the rights to free, appropriate public education and specific services to ensure his student rights. Section 2. Legal and ethical issues. First, the abruptness of this change in schedule could have had some possible emotional harm upon Miguel. Second, the legal representation for Miguel could easily bring forward discrimination charges, possibly violations of LRE, Least Restrictive Environment, FAPE, Free Appropriate Public Education, and the Rehabilitation Act of 1973, which was specifically designed to eliminate discrimination on the basis of handicap. Next, the counselor made an independent decision with no understanding or thought to how Miguel might feel, have his schedule rearranged without his knowledge or consent, nor did she give any thought to Miguel's rights as a student. Additionally, Miguel does qualify for legal protection under Section 504, and his parents are entitled to a hearing to determine what services are insured to Miguel. Lastly, if there was no breach of duty, nor any violation of duty of care, the school and its agencies are not liable for financial compensations due to Miguel's injury. Jueli in 2019 says that if there was no malicious or intentional intent from the opposing team's player, then assault and battery charges are not applicable. Usually during school sports, there's an assumption of risk, meaning there's a chance to get hurt, but players play anyway. So Section 3 synthesizes what has happened into one sentence. So this one-sentence wonder may prove to identify a creative, focused, and manageable topic that addresses significant but less explored aspects of the topic. Miguel Hernandez suffered permanent paralyzation, found his academic schedule rearranged without prior knowledge or consent, and now retained an attorney to defend access to a college-required prerequisite class. Section 4 synthesized the facts. The people in the case study include Dr. Harvey. He is the superintendent of the school and knows and works well with all staff at all the sites. Community. The community involves teachers, administrators, parent volunteers, and they provide programs and services for students at each of the 9 sites, and they love to devote time to the Friday night football team to cheer and celebrate. Miguel. Miguel is a dedicated high school student with college aspirations who is also the starting quarterback. He encouraged teammates to do their best, spoke to his coach about how to improve the next game, and he triumphed over a permanent disability by soaring through rehab and keeping up academically. He is motivated to return to school and beyond that, college. Mrs. Guzman is the high school counselor who required a physician's note for Miguel to return to school. She met with parents and confirmed that the only accommodation Miguel needed was wheelchair access to the classroom. She told Miguel on his first day back she had unenrolled him and changed his schedule because one of the classes didn't have wheelchair access. She had no regard for how this massive change would affect him emotionally. She didn't give him any thought to be considered negligent in her duties and to understand and follow any laws she may have broken by making such a thoughtless move. As a counselor, she should have known Miguel's aspirations to attend college, and knowing that, she should have known that the particular biology course Miguel was enrolled in was a prerequisite course to the college degree he aspired to attain. The case study introduces Mr. and Mrs. Hernandez as Miguel's parents. They moved Miguel and the brothers to Dover Unified School District for the amazing academic program and to play football. After Miguel's accident, they helped Miguel through months of rehab and helped him keep up academically. They are rightfully upset when, after going out of their way to give 2 weeks' notice that Miguel would be back at school, the day Miguel returned to school, they discovered that their son's schedule was changed without prior notice, and that he had been unenrolled from his college prerequisite biology class. Naturally, they requested a meeting with the site administrator and immediately retained an attorney to represent their son's school rights. The attorney of this case is Howard Carey, who represents Miguel and gives a brief question regarding Miguel's rights and is very knowledgeable about what those rights are and how they may have been violated. The case study revolves around Dover Unified School District. This district has 9 sites. There are 6 elementary, 2 middle, and 1 high school called Nottingham High. The school was built in the 1950s. Due to expanding student body, there are trailers to accommodate a growing population of around 3,200 students. The district has brought most of the buildings up to code. However, some of the buildings at the high school are not quite up to federal state code with regard to accommodating individuals with disabilities. They lack the funds, and about a quarter of the high school building remains how it was when it was built in the 1950s. The community is a place in the case study that parents volunteer with teachers and administrators to provide programs to services and students. The community revolves around Nottingham High School. In fact, the case study goes so far as to call it the central hub of activity. The community is a place that comes together to cheer for the many wins earned from Nottingham High School. Nottingham Public High School has a successful academic program and football program according to the state directory that identifies it as an outstanding high school. Section 5, Review and Prioritize. This situation could be very damaging to the school and community at large. Miguel is a very popular person because of his positive attitude, star quality football quarterback skills, good teammanship, genuine desire to improve at football, and his most recent recovery. The action of the counselor and an impending lawsuit that could conceivably bankrupt the district could all undo the positiveness that Miguel and his family worked hard to achieve from such a horrible accident. And in the worst-case scenario, undo all the work the community, superintendent, principals, and parents and students do to make this school district outstanding. The stakeholders for this case include the superintendent, principal, counselor, nurse, Miguel and his family, and possibly a physician. There was a breakdown in communication with regards to the counselor, who took it upon herself to unenroll Miguel from classes without communicating the reason she had done so. When the Hernandez family stated that Miguel needed no accommodation save the wheelchair access to class, his current classes should have been reviewed and screened for their wheelchair accessibility. Concerns and schedule changes could have been brought up in a safe and collaborative environment. Before I made any decision as a principal, I would have to know what is involved in moving a biology class to a wheelchair accessible room. I will need to know if there's a district handyman to build a lift or a ramp to give wheelchair access to the biology class. Additionally, does my school have emergency funds to rapidly cover such construction or modification? Does my school or district have a budget that includes mid-year construction? I'm going to need all my stakeholders to come together, brainstorm ideas of what to do for the next day of school. I have a few days of my own, but I really need to honor the amazing staff I rely upon and the community at large to make this right again. Options and consequences. Option 1 is do nothing. The consequence: Miguel does not attend college, nor does he even finish high school because everything is different. Consequence: lawsuit from the Hernandez family which bankrupts the school district, and children all over the community are displaced. The building leader is ultimately responsible for these decisions and may be in danger of receiving disciplinary actions. Option 2: re-enroll Miguel in science class immediately, effective that day. Consequences: some positive, some negative. Here's my ideal. Miguel finishes school, he attends colleges, and he cures paralysis. I request Ms. Guzman to make an apology, and she learns that that was not the appropriate way to handle scheduling. There is a mandatory review for all staff on procedures for following all 504 and IEP accommodations. Funding may be denied for a ramp or lift to classroom. Consequences may also include a teacher filing a grievance for a hostile workplace when I ask her to move classrooms mid-year to teach from a wheelchair-accessible room. Positive consequence may be that the community comes together. They build a lift or ramp virtually overnight and it passes inspection, and this act alone inspires the whole community to reconstruct the remaining quarter of the school. The football team raises money to partially fund the reconstruction, and the community donates their time and funds to complete and update the entire school. The newly renovated part of the high school is now named Hernandez Wing. Ultimately, in both options, the building leader is responsible for these actions and ensuring that all staff strive to promote equity, inclusiveness, and cultural responsiveness. In fact, all items highlighted in yellow for the remainder of their presentation indicate NELP Standard 3, Equity, Inclusiveness, and Cultural Responsiveness. So Section 7, evaluate the options. The first thing to consider is not rushing to any decisions. It is important to give the Hernandez family a chance to put together their thoughts. The lawyer said that he wanted to make sure all Miguel's rights were protected, so perhaps it would be fortuitous to listen further to what those needs may be. During this time, an agreement may be reached that all are satisfied with. This calm, do-nothing stage could be a wonderful learning opportunity to discuss options. These types of conversations and negotiations are not admissions of guilt. In fact, Nyhan in 2017 said that settling a case doesn't mean you've done anything wrong. It ends an incredibly expensive and risky litigation process that you cannot control. The cons to doing nothing include Michael not receiving an appropriate education. There are laws such as LRA, FAPE, and Section 504 that may be broken. The family is upset and the situation may worsen. Pros to option 2. Re-enrolling Miguel in his former science class include offering an immediate solution. Here we may be assured that Miguel continues to receive an appropriate education and the family will be appeased. Additionally, the lawyer will drop any pending lawsuits and money is saved. Another pro is that Ms. Guzman understands how completely wrong her actions have been and learns to avoid them in the future. Lastly, the district maintains their confidence level. Cons to this option include the fact that a principal may be offering much more than necessary and overcompensating. If promises are made that include monetary requirements, modifying building structures, there may be trouble funding the project. Lastly, a whole class may be displaced if you went with that route to move the class to a different room that is wheelchair accessible. Section 8. My best bet is a combination of both options. First, I'm going to review all the laws. Then I need to hear what the parent and lawyer would like. After that, I will open a dialogue regarding solutions, and later we may have an amicable decision. Following that, I will implement those decisions, and over the next day, there may be possible disciplinary actions for Ms. Guzman. At the very least, she will need to explain her decision-making process during the meeting. After all is said and done, it will be crucial to remember that an administrator should be communicated with regarding any schedule changes or modifications to a 504. Lastly, this is a wonderful time to remember that once a year, a review of LRA, FAPE, and Section 504 for all staff will ensure that all students receive equitable access to educational resources. Section 9. Imagine implementation of chosen path. For my chosen path, I will first contact the superintendent and let him know my thoughts. I will gratefully accept feedback. If agreed upon, Miguel will be re-enrolled in the class, and I will listen to the parent concerns. I am confident that I could come to an agreement with Miguel, his parents, and the attorney regarding a solution. Some things that may happen are these. The lawsuit may be dropped. We may reach a mutually benefiting decision. There may be lessons learned, meaning no more future lawsuits. The stakeholders will need to be contacted if further action involves monetary needs. Additionally, contacting teachers, special services, nurses, counselors to help find solutions will be crucial to ensure that equitable educational resources and opportunities and guidelines are followed. The staff will be given an opportunity to practice critical thinking and problem solving for the success of all their students. At the principal and superintendent discretion, Ms. Guzman may receive a disciplinary action letter on her file. The principal may also receive a disciplinary action letter for not attending the initial meeting and for not being aware of the schedule change. The people who need to know about the situation include teachers, support staff, and the superintendent. Really, these people should have been involved and communicated with from the beginning. Moving forward, it will be best to deal with the issue informally and not involve the law. Before meeting with the Hernandez family, I will contact the superintendent. I don't want to threaten the Hernandez family. I do need to communicate my thoughts with the superintendent and receive feedback before this meeting. I will speak compassionately and genuinely, and with the Hernandez family, maintaining decorum at all times. My backup plan is to provide Miguel with the same class, but with a different setting. I may accomplish this with video chat, virtual labs, Google Classroom, and perhaps an alternate preparatory class for college requirement. All the elements remain the same. If my first and second plan of action do not work and the Hernandez family refuses to negotiate, go straight for a lawsuit, my next steps would be to recontact the superintendent after having taken detailed notes of meetings, review the entire situation with my entire district attorney. Additionally, I will contact my communications PR person and assess damage control. My references are here. This concludes my presentation, and thank you kindly for listening.